Ladies and gentlemen, dear colleagues, Mr. Chairman, dear Ivan, thank you very much. Good afternoon. First point of my presentation is introduction, the paradox of constitutional responsibility. And at the beginning, I would like to talk that my topic is quite the next step of presentation that Professor Wielec told us before the coffee break, because I would like to talk about the paradox and propose some de lege ferenda constitutionalis proposition. Constitutional responsibility is one of the classical institutions of constitutional law. Yet it is also one of the most paradoxical. It is designed for extraordinary situations, for moments when the conduct of the highest public officials threatens not only ordinary legality, but the constitutional order itself. At the same time, it operates precisely where law and politics are most difficult to separate. This is the starting point of my paper. Constitutional responsibility should not be understood simply as another sanctioning mechanism, nor should it be reduced to a political weapon used after a change of parliamentary majority. It is better to view it as a constitutional safeguard, an exceptional mechanism which must be strong enough to protect the Constitution, but restrained enough not to become an instrument of constitutional revenge. The Polish model has a particular history. The state tribunal was introduced into the constitution of the Polish People's Republic by the constitutional amendment of 26 March 1982. The new constitutional basis was Article 33b of the 1952 Constitution, which entrusts the State Tribunal with adjudicating on the responsibility of person occupying the highest state office for violation of the Constitution and statutes. This historical origin is important, but it should not dominate the analysis. The more important fact is that after 1989 and under the Constitution of 1997, constitutional responsibility has remained largely a dormant institution. Its practical use has been limited. The so-called alcohol affair remains the principal example of proceeding indicting of conviction before the State Tribunal. Other cases either did not reach the adjunctory stage, became excessively prolonged, were blocked by political arithmetic, or appeared recently in conflicts concerning constitutionally independent organs, such as the President of National Bank of Poland and the Chair of the National Broadcasting Council. My central thesis is therefore the following. The Polish model of constitutional responsibility does not need a merely technical corrections. It needs a constitutional reconstruction. The aim should not be to make constitutional responsibility easier in every case. The aim should be to make it credible, selective in the scope, juridical in its procedure, and resistant to political instrumentalization. Point number 2, methodological premise between law, politics, and constitutional protection. Before discussing reform, one methodological point is necessary. Constitutional responsibility cannot be analyzed only through the text of procedural provision. It must be examined on 3 levels, in my opinion. The first is the dogmatic level. Who may be held responsible? For what conduct? Before which organ? And under which procedure? The second is the institutional level. How the mechanism actually works in the system of parliamentary majority, party conflict, and constitutionally independent organ. The third is the axiological level. What constitutional values the institution is supposed to protect. These values include legality, fidelity to the Constitution, separation of power, independence of constitutional organs, and the right of the accused person to a fair and predictable procedure. If we ignore the dogmatic level, reform becomes rhetoric. If we ignore the institutional level, reform becomes naive. If we ignore the axiological level, reform becomes merely technical. A serious de lege ferenda constitutionalis proposal must therefore connect all three levels. Point number 3. The current model in one sentence. The current Polish model may be summarized in one sentence. The Constitution provides for the responsibility of the highest public officials before the state tribunal for violation of the Constitution or statutes, and in certain cases also for offenses. But the initiation of proceedings depends on parliamentary decision-making. This construction is hybrid. It's not ordinary criminal liability because it concerns the performance of constitutional office. It is not merely political responsibility because it may lead to legal sanctions imposed by a formal adjunctory body. Hybridity is not necessarily a defect. Many constitutional mechanisms combine legal and political elements. The problem appears when the model does not clearly determine where politics must stop and law must begin. Point number 4 of my presentation: three structural weaknesses, in my opinion, of course. The first weakness is the overbreadth of the constitutional delicte. The formula of violation of the Constitution or a statute is too wide if read literally. It may cover serious abuse of office, but also legal errors, doubtful interpretations, and marginal irregularities. The second weakness is political gatekeeping. The decision to bring a person before the state tribunal depends on parliamentary majorities. This cannot be entirely avoided. The third weakness is the risk of premature punishment. In some cases, the parliamentary decision to bring a person before the state tribunal might produce immediate consequences for the exercise of office, including suspension. Suspension might sometimes be necessary to protect the office or the proceedings. These three weaknesses point to the same conclusion. The problem of the Polish model is not simply inactivity. The deeper problem is the lack of the stable constitutional grammar, a grammar capable of distinguishing accountability from retaliation, constitutional violation from political disagreement, and procedural necessity from distinguished sanction. And now, point number 5, the lege ferenda constitutionalis, or test for a credible model. In my view, the future model should be built around 4 tests. These tests do not require the abandonment of the constitutional responsibility. On the contrary, they are designed to save it as a serious constitutional mechanism. The first is the material delicte test. Constitutional responsibility should arise only in the case of a qualified violation of the Constitution or statute. Such a violation should be serious, culpable, and connected with the constitutional function of the person concerned. Seriousness is needed to exclude marginal branches. Culpability, at least in the form of gross negligence, is needed because responsibility of this kind cannot be based on an objective irregularity alone. The functional connection is needed to distinguish a constitutional delict from ordinary illegality or the ordinary criminal conduct. This test would change the logic of the institution. Constitutional responsibility would no longer be triggered by the abstract fact that some legal norms was violated. It would be triggered by conduct that undermine the proper exercise of constitutional office or treat as constitutional values of reporters. This is the most important reform because without a material concept of the constitutional delict, all other changes remain secondary. The second is the anti-instrumentalization test. The parliamentary stage should not disappear, but it should be disciplined. A format model could require an independent preliminary legal opinion before the final vote. Such an opinion would not replace the political decision, but it would oblige the parliamentary majority to confront legal criteria. It would also make purely relationary motion more difficult to justify. In addition, voting threshold should reflect the constitutional position of the person concerned. The more independent the organs is meant to be, the stronger that procedural guarantee should be. This is particularly relevant for organs such as National Bank of Poland or the National Broadcasting Council. Their independence is not a personal privilege of office holders. It is an institutional guarantee of the constitutional order. The third is the fair procedure test. The adjudicatory phase must be generally judicial. Church should be precise, evidence should be assessed according to clear standards. The person accused should have full right of defense. The proceedings should be conducted within responsible time. The fourth is the proportionality test for suspension and interim measure. Suspension from office should not be automatic. It should require a separate decision based on the gravity of church, the risk to the proper functioning of the office, and the need to protect the proceedings. It should also be time-limited and subject to review. Otherwise, the initiating decision may pressure the practical effect of a final sanction without a final judgment. This fourth test should be supplemented by a clear separation between constitutional and criminal responsibility, as Professor Wielec told us morning. Ordinary criminal offenses should, as a rule, be assessed by ordinary criminal courts. Constitutional responsibility should focus on the abuse of constitutional powers, obstruction of constitutional duties, and serious disregard of constitutional limits. This distinction would make the institution more coherent and would protect it from becoming either a substitute for criminal prosecution or a symbolic political trial. Conclusion. Responsibility without revenge. The reform of constitutional responsibility in Poland should not be reduced to the question of whether the state tribunal should be activated more often. Frequency is not the measure of success. A constitutional mechanism may rarely use and still be effective if its existence shapes the conduct of public officials. Conversely, it might be used often and still be destructive if it becomes an instrument of political retaliation. The real question is different, in my opinion. Can constitutional responsibility become a credible safeguard of the Constitution? My answer is yes, but only under strict conditions. The delict must be material and qualified. The parliamentary stage must be legally disciplined. The adjudicatory stage must be generally judicial. Interim consequences must be proportional. And the whole mechanism must be designed with a special care with its constitutionally independent organs. Constitutional responsibility is located at the boundary between law and politics. If the boundary disappears, responsibility becomes revenge. If it is drawn too widely, responsibility becomes fiction. The task of constitutional reform is to find the middle path, a mechanism strong enough to protect the Constitution, but restrained enough to respect the rule of law. This is why, in my view, the future of constitutional responsibility should not be built on the language of punishment alone. It should be built on the language of constitutional fidelity. The point is not to replace politics with law completely. The point is to ensure that when politics reach the Constitution, it remains bound by law. Thank you very much for your attention.